Well, this is called the Chipman Mazzucco's Emerson's 25th Annual Estate Planning Seminar. It really is probably the 40th estate planning seminar for Rich Land, who is, Rich, if you'd please stand. I mean, we're all happy to have you here. Thank you for all your help over the years and for pulling this together tonight. Thank you. In addition to the information about the lawyers in the firm, the last piece on the left side could come in very handy. We all have the problem of, what am I going to watch on Netflix? What am I going to watch on Amazon Prime? Does anybody have something good to watch? Well, if you can't come up with anything else, there are 111 videos, estate planning, done by Rich Land. So I certainly, for those of you who have not seen any of them, they're certainly worth taking a look. And again, it's our pleasure to welcome you here. Our first speaker of the evening is Alyson Marcucio, who's going to talk about elder abuse, what to look out for, and what can be done to prevent it. And without further ado, I'll turn the podium over to Alyson. You're welcome.
Thank you, and good evening. It's great. I don't know, you can hear me okay? Okay, good. It's great to see everybody. We're so happy to have such a wonderful turnout after a couple years of kind of being in hiding, all of us, right? And as Fran said, I'm going to be talking a little bit about elder financial abuse, senior financial exploitation. And let's see. Elder financial abuse, senior financial exploitation. It may sound pretty straightforward, but may be scary too. In reality, it's quite complicated and unfortunately very common. The estimated loss of elder financial abuse each year is about $3 billion. It affects 2 to 5 million adults over the age of 65. 1 in 6 adults over the age of 65 have been affected. It's more prevalent than child abuse, but not as reported as child abuse. Often 1 in 14 cases are reported. That's it. Often underreported, underrecognized, underprosecuted. Why? Well, many reasons. Fear by the victim of retaliation, and I'll talk about that a little bit more in a few minutes. The senior may feel partially responsible, or there may be some denial that somebody who cares about them is actually taking advantage of them. So I'm going to start with a story about Mama Molly and daughter Dolly. Okay? Mama and Dolly lived together for many years in Mama's house, and Dolly had gone through a divorce. She needed a place to live. Mama and Dolly, they talked, decided it made sense for them to live together, and Mama was going to help Dolly get back on her feet. Mama is financially stable. Dolly needs some financial help, and Mama's happy to provide it. So early on, Mama's relatively healthy, paying all the household bills, helping with some of Dolly's bills, paying car insurance, giving Dolly some spending money. Again, helping her get on her feet. Probably a common scenario in a lot of families. As the years pass, Mama puts Dolly on as her power of attorney so Dolly could help pay bills if she needs to. And Mama's health begins to decline. And as Mama's health begins to decline, she has to start dipping into her savings to start paying for some of her health care costs. Dolly starts writing checks from Mama's accounts. She's power of attorney. She has the authority to do that. And she continues to pay some of her own bills because her mother's been doing it all along, so why not, right? Continue the pattern. So she's paying Mama's bills from Mama's accounts, paying her own bills, again, car insurance, some spending money. But as the years continue to go on, Mama's running out of money. And she may need to get a mortgage in order to continue to pay her bills and to continue to live in her home. Dolly knows this, but still continues to use Mama's money to pay her bills, pay Mama's bills, and again, continue the pattern that's been going on for a number of years. So you ask yourselves, is this financial abuse? Is this financial exploitation? And if so, when did it start? So I want to look at the definition by the Older American Act of what financial abuse is, or financial exploitation. And bear with me for a second. I mean, this is, law, so of course it can't be simple, all right? So elder financial abuse or financial exploitation, defined as the fraudulent or otherwise illegal, unauthorized, or improper act or process of an individual, including a fiduciary caregiver, that uses the resources of an older individual for monetary or personal benefit, profit, or gain, or that results in depriving an older individual of rightful access to or use of benefits, resources, belongings, or assets. So, really simple definition, right? What does that really mean? Well, break it down, an individual taking advantage of an older individual for their own personal financial gain. I mean, why we can't just simplify it, right? But, okay. So, how does that apply to Molly and Dolly? We look at the definition. Is what Dolly is doing fraudulent? No. Is it otherwise illegal? No. Let's skip unauthorized and improper for now. Is it an act of an individual using resources of an older individual? Yes. For monetary or financial gain? Yes. Does it result in depriving an older individual of use of the money? Yeah, maybe. Molly doesn't have enough money without getting a mortgage to continue paying her own bills. We go back to unauthorized and improper. This is a practice that's been going on for a number of years. The only difference is, in the past, Mama was signing the checks. Now Dolly, as power of attorney, is signing the checks. So does this rise to the level of financial exploitation? Is it an improper use? Is it authorized? Many questions arise, so that's where it gets very confusing as to whether or not and at what point financial abuse or financial exploitation might be beginning. So how could things be done differently, or how could they have been done differently? And once this practice starts, how can it be stopped? That's where it gets even trickier. Sometimes in situations like the one involving Molly and Dolly, Molly is afraid of retaliation if she tries to stop the pattern. It's been going on for many years, and if all of a sudden Mama says, you know what, I can't help you anymore, it has to stop, what if Dolly is helping providing care for Mom? Is she going to continue to pay? Mom might be afraid. Is Dolly still going to bring me to my doctor's appointments? Is she going to still help me out with things I need? All right? What could she have done differently? Well, I mean, yeah, she could have had a discussion with Dolly early on when she first moved in to say, hey, this is temporary. I can help you out financially for a short time, but once you get back on your feet, then I'm not going to be able to do it. I have to make sure I'm preserving my savings for myself if I need it down the line. But as some might realize, the actuality is trying to stop the pattern later on, even with that conversation, might be impossible. Maybe instead of Mama naming Dolly as on her power of attorney, she names somebody else. Maybe she names a trusted advisor, okay, whoever that might be. Maybe not a good idea to name a different child. So if another child lives in another state or maybe in the same state, may not be an ideal situation because it could cause strife between the two children if Dolly is all of a sudden deprived of some financial help and her sister or brother is not willing to continue that financial help. But again, naming a trusted individual, whoever that might be, and explaining in advance to the individual that, yes, I've been providing this financial help to Dolly, but the expectation is it's not going to continue on indefinitely, and at some point it's going to have to stop, and if I need assistance and care, I'm hoping that this pattern, this financial help will stop so that I have enough money to live on. Okay. And then you have sort of a checks and balances, so it's not, Dolly doesn't have an automatic ability to just access the funds. Okay? Another way is with a voluntary conservatorship, and I'm not going to get into great deal detail, but voluntary conservatorships is a proceeding through the probate court that allows an individual to designate a conservator of their choosing, but it's with probate court oversight. So there's accounting requirements to the court, and it provides, again, a level of oversight. It's kind of the step above a power of attorney. Now, there could be abuses with a conservatorship also, but with the probate court oversight, at least there's a kind of the next level up. Of course, with the conservatorship, there's added cost and paperwork, so some people don't, they want to try to avoid the conservatorship. I want to talk about another example. Now we're going to talk about Marty. Marty's children, they live out of state. Marty lives in his own home. He has a live-in aide. And Marty has some cognitive impairment, but he's not able to manage on his own. He needs some assistance, thus the caregiver, the 24-hour caregiver. Marty could still sign checks, but he struggles to see. And the children, they visit a few times a year, but they talk to him maybe every couple of weeks. The caregiver, she goes above and beyond, brings him everywhere. Church, brings him to his appointments, senior center, visits with his friends, wherever he wants to go. This caregiver is great. Marty still likes to be involved with the payment of his bills, but again, he can't necessarily see everything clearly. So the caregiver has assured the children that she'll write out the checks for Marty and he could sign them. And by the way, the caregiver failed to mention to the children that Marty bought her a car, but, he signed the check, so that's not a big deal. Oh, and sometimes when they go shopping, the caregiver will throw things in the cart, personal items, but again, it's not a big deal because it's just a few things here and there. No reason to mention that to the children either. Is this elder financial abuse? Sounds like it might be a case of somebody building a level of trust and using it to financially exploit the victim. Sometimes you see situations where a caregiver will begin to isolate the individual. Children will call, want to talk to their parent. Caregiver will say, nah, they're busy right now. Mom and dad's sleeping. The isolation begins. So it's kind of a sign that maybe something's going on, isolating that parent further and further. What could be done differently? Well, I think number one is don't ever get the caregiver involved with the finances, no matter what. Definitely with a professional caregiver, but maybe even if it's a child who's providing the care. Keep them separate. Keep the caregiving role separate from management of the finances. Because once you combine the two and it's the same person, it could be a recipe for disaster. The other way, and this is not by any means an advertisement for what's called TrueLink, but I have used this TrueLink as a tool, and some of my clients have, with conservatorships and when there's caregivers in the home. What TrueLink is, you go online, you order this TrueLink card. It's like a debit card or a credit card. And if there's a caregiver in the home, this TrueLink card is kind of like a prepaid Visa card. It's kind of loaded with money, all right? So let's say a child is out of state or family member's out of state. They're actually controlling how much goes on this card, okay? So let's say they could do it automatically, or it's as, or it doesn't have to be automatic. So let's say they automatically fund this card from mom or dad's account, $500 a month or whatever it is. The caregiver then can use that card for whatever purpose the child or whoever's kind of managing this account. They could restrict the card so that it could only be used at pharmacies, or it could only be used at grocery stores. You could limit one purchase, so anything over $100 is going to send an alert to the individual that's managing the card. And it provides these accounts so that the child could kind of monitor and make sure that there's not an abuse, and it limits access to your account. Okay, so again, I've used this with some of my clients when they've had caregivers in the home or with conservators to kind of limit the use of the funds by a caregiver or a conservator. All right. So I've talked a little bit about a couple different types of perpetrators. Family members, believe it or not, are the most common perpetrators of elder financial abuse. More than 50% of the financial abuse is by family members. Friends, around 17%, caregivers, 15%, and then you've got the lovers, the girlfriends, the boyfriends, other trusted individuals, and abuse using a power of attorney. So what can be done? I've identified a few things, but are there other ways to eliminate or reduce the chances of elder financial abuse? Well, public education, like tonight, kind of identifying some risks and things to look out for. And sometimes we go through life and we you trust this person, and we have to have some level of trust, but kind of identifying some of the risk factors and just being vigilant. What can we do to prevent TrueLink card? Can we use that? Is that going to help us in our lives? Choosing who our agent under a power of attorney is going to be carefully, because power of attorney, it's a really powerful document. You're giving a lot of authority to somebody to manage your finances on your behalf. So maybe the ideal solution is to have a multidisciplinary team. What do I mean by that? A team of professionals. It could include attorneys, geriatric care managers, accountants, investment advisors, professional bookkeepers, bankers, whatever that team of professionals might look like, who has been involved in your life, who knows your finances, who knows your the legal side of things, so that they could kind of be on the lookout. So maybe while you have the capacity and you're looking at your statements, everything is fine. But what happens if you become impaired in some way and you're no longer keeping an eye on your statements? Or maybe you're fully capable of looking at your statements, but you just have the individual in your life that you trust, and again, could be a family member, that is really taking advantage of a situation. Having that team of professionals who's familiar with your spending habits, who's familiar with your financial picture, to kind of look out for you and talk amongst themselves, authorize them to talk amongst yourself. Maybe that's the key to protecting you from this elder financial abuse. Unfortunately, there's no one solution, one size fits all solution. Again, it's all about being vigilant, and who's going to be vigilant for you if you can no longer look out for yourself. All right. I want to touch on one other example, and this involves trusted individuals, okay? So not necessarily a caregiver, not family members, but grandchildren decided they wanted to stay connected with grandma, so they bought her an iPad for her birthday. They helped her set up everything. They gave her the contact information for Apple in case she ran into problems. And one day, she had problems. She didn't want to bother her grandchildren, so she went off to the Apple store. And I don't know if you've ever gone to the Apple store or any other tech store, but it's a nightmare. And she was overwhelmed. And by the time she left, she just didn't even know which direction she was going. And she walked out, there was a woman she recognized from church. And the woman asked her what was wrong. And she said, I'm trying to figure out something on my iPad. I can't figure it out. And the woman goes, oh, well, perfect. I started this business, Computer Help for Seniors. Perfect. Gave her a card. Give me a call if I could help you out. So Grandma went home, and she's like thinking about it. And she decided to give her a call, pay the lady $100 an hour for a consultation. The woman was fantastic. Came to the house, she spent 3 hours with Grandma, helped her set up online accounts. She was even nice enough to help her set up her financial accounts. And the lady, she took screenshots of Grandma's financial account, all the financial accounts, just in case Grandma needed help later. Because, then she'd have all the information at her fingertips and she wouldn't have to go back to the house. So perfect. And Grandma didn't make it a habit to check her accounts online on a regular basis. She knew she got the statements. So next time she got her statements, guess what? She was $50,000 overdrawn, and her credit card had $25,000 balance on it. So she pulls out the woman's card, calls her, and then she realizes, well, wait, the lady hasn't been in church anymore, and the number is disconnected. It's not in service anymore. So now she has quite a loss, and what does she do? Well, she could go to the police, but it's very difficult to recover that money once it's gone. What could she have done differently? Well, could be careful. Maybe this is obvious, but being careful with who you share your financial information with. It's very easy to trust people that are being helpful and trying to show you, but to go that next level of sharing that financial information may not be the best way to proceed. Money's powerful. We see it all the time. During life, at death, money, it just tears families apart. Families that once got along, money just tears families apart so often. It creates so much conflict. And like I said, once there's a financial loss like this, it's next to impossible to recover it because it's costly. And how are you going to recover if it costs money to recover and you have no money to use to recover that loss? Unfortunately, criminal prosecution for elder financial abuse, because of budgetary limitations, lack of evidence, maybe the senior is no longer living, can't provide the evidence. Often the victim or the senior doesn't want to cooperate. Again, going back to fear of retaliation, wanting to keep the family together if it's a family member. They don't want to prosecute. And lack of support by law enforcement, adult protective services, it's, I can't say enough, very difficult to recover. So the best thing is the prevention, and there's been legislation aimed at elder exploitation and elder financial loss, coordination between different agencies to kind of keep an eye on what's going on, and having registries to report people that, kind of like the child abuse registries, they're trying to start having some registries of people that the perpetrators of financial abuse and financial exploitation. So just to recap, some of the ways to attempt to prevent financial loss. The multidisciplinary teams, the professionals with the accountants, attorneys, bookkeepers, geriatric care managers, whatever that consists of. maybe powers of attorney, but making sure that you're naming somebody on the power of attorney that you absolutely trust. Voluntary conservatorships, the extra level of supervision by the probate courts. Maybe the use of revocable trusts. I didn't talk about the revocable trust, but with a revocable trust, you're designating a trustee. It could be a bank, it could be an individual. So again, getting people in place that are going to look out for you at such time when you may not be able to look out for yourself. Being vigilant and just being educated. So, thank you very much and enjoy the rest of your evening.
Before Alyson leaves the podium, if anybody has any questions for her, I'm sure she'd be happy to take them. And if you don't have any questions now, her email is in the literature, and I'm sure she'd be happy to respond to an email. So again, thank you, Alyson.
Thank you.
And while listening to Alyson, one other area of elder abuse, and it's not just elder abuse that came to mind, are the phone calls that we all get from auto warranty companies or the IRS telling us we owe money, or a whole variety of other phone scams. And those are things that we need to watch out for, and that we need to watch out for our, in my case, my 96-year-old mother. I did want to, on your table, you'll find a little box, and that is a present, a gift to you for coming. For those of you who haven't opened it yet, it's a nice little pad. It has a pen, and there are some other things inside that would allow you to either write on the slides that are part of the package, or put some stickies on if you have any particular questions. Our next speaker this evening is Jim Flaherty, who is a lawyer in the Southbury office, who's going to be speaking about residences and domiciles and changes. The last few years, we've seen, frankly, probably an influx of people coming to Connecticut from New York and other states to escape COVID. Over the years, we've also seen a number of our Connecticut clients leave the state to go to Florida because it has favorable tax treatment. Unfortunately, with that favorable tax treatment, sometimes comes hurricanes. And first of all, apologies to anybody, and my condolences to anybody who knows anybody or has property in the Fort Myers area. But I'm sure if anybody's looking to establish a domicile in Florida, there's probably some good deals to be had in that area. And again, without further ado, I'd like to introduce Jim Flaherty.
We're grateful you're here tonight. For those of you who might have been here in 2019, my presentation tonight is going to be remarkably similar, and for some of the reasons that Fran just touched on. March of 2020 changed the landscape for estate planning dramatically. I read somewhere, and this was a few weeks ago, that they believe 30,000 people exited New York and came to Connecticut subsequent to the onset of COVID. You've seen the license plates, they're all over. They're here, and we're glad to have them. But it has changed the landscape in terms of how we do estate planning. It's no longer uncommon to have one or more, or two or more residences. So how do we deal with that from an estate planning standpoint? When I talk to folks and they have multiple residences, the first thing I want to know is, where do you truly live? Where do you spend your time for the most part? And we talk about the definition, sure we do, there we go, of domicile. It's the place, so tax authorities, which is what we're most concerned about, but it is also from a probate standpoint, tax authorities want to know where you intend to live, what is your permanent residence, and if you leave that residence, where do you intend to return? Where do you spend the most of your time? Once established, your domicile remains unchanged until you make affirmative election to change it. So it's by moving to a new location with a bona fide intention of making it your fixed or permanent place of residence. You can generally only have one domicile. So if it's Connecticut, it's Connecticut. If it's Florida, that's another thing. If it's New York, that again. However, tax authorities, being what they are, will at times both seek to establish your domicile for you. So we're going to talk a bit about how you establish domicile and why it's so important from an estate planning standpoint. You may have residences in 2 or more places, but again, only one domicile. "183 days, that's the magic number. You spend more than 183 days in any given jurisdiction, you're considered domiciled in that jurisdiction for tax purposes, and that's the rule in most states, particularly where we're at now in Connecticut, New York. It's an extraordinarily important number. So how do you change your domicile? So for example, if I'm looking to move to Florida, how do I do that? Well, first I establish that permanent place of abode. In Florida, you can actually sign a declaration of domicile. The county courthouse in Florida will have a form that you can fill out, and you file it with the clerk. Registering to vote is extraordinarily important. Get your driver's license in that jurisdiction. Register your automobile. When you go to file your income tax return, your 1040, make sure it's with the service center for that jurisdiction. And where you can, maintain your financial accounts with local banks in that jurisdiction. If nothing else, change the address. If you have professional licenses or union memberships, make sure that gets changed as well. And there are ways to become a non-resident of various organizations you might belong to, whether it's religious or fraternal, those sorts of things. Keep a record of your travels. In Connecticut, when we lose a client and we're probating their estate, there are times when those clients will have moved, for example, to Florida. Recent example, lady moved to Florida. I was not aware of it until after she had passed. But she still owned her condo here in Connecticut. So we had to do what's called an ancillary probate administration. Rather than getting a full-blown probate going, it was just particular to that property here in Connecticut. And as part of that process, the state of Connecticut wants to make sure that, in this case, that she was actually a resident of Florida. And, excuse me, there was I think it's about 4 pages, and it's an affidavit that's filed by the proposed executor as to why this person should not be considered a Connecticut resident. And they want to know, where did you file your taxes? To whom do you pay property taxes? What organizations do you belong to? What doctors do you visit? Extraordinarily important, because many people may not be resident or domiciled in Connecticut anymore, but they'll still come up because they trust their doctors. That's going back to when I mentioned keep records of your travels and why. That's why. You want to make sure that if you're visiting Connecticut just to see your doctors, that that's logged in. Still counts toward those 183 days, but it will allow you to make sure that you don't exceed the 183 days. There are ways to revoke domicile. There are affirmative actions you can take. For example, removing your name from the voting rolls or surrendering your driver's license. You can also notify local municipal tax authorities of your change of address so that, for example, when your property tax bill comes due, it comes to your new residence in Florida. Don't cut it close, because it's very easy. If you planned on spending 5 months in Connecticut and 7 months in Florida, and an intervening occurrence, something happens. Maybe it's an illness, or maybe a family issue where you have to stay longer. If you're coming up on that 183 days, you need to know that, and you need to make arrangements. So I guess the advice is don't front load your time in the jurisdiction in which you don't want to be domiciled. Because even a part of a day counts as a full day. I use the example of a gentleman, he was in New York, and he was trying to avoid being a New York domiciliary. And he landed in JFK, happened to stop just to get something to eat on his way to New Jersey so he could get out of New York. Didn't matter. How did they know? They saw the Easy Pass, they could see the ATM usage, they could see his credit card usage, his cell phone usage. All of it counted and pushed him to 184 days. That's all it took. So my advice is don't cut it close. So when we're looking at estate planning, we're looking at it from a couple of different aspects. The first is we want to make sure your property goes where you intend for it to go. That's the really basic part of estate planning that's so important. You want to make sure that if your children are the intended beneficiaries, that they get that property. If you want it to go into trust for your children, that it goes into trust for your children or your grandchildren or whomever it might be. But the second, and probably, well, it's equally important, and that is we don't want any adverse tax consequences to any transfers that we make. So knowing which jurisdiction we're dealing with is extraordinarily important. Connecticut has an estate tax. Currently, it's the first $9.1 million can pass to your heirs other than your spouse, because property going to a surviving spouse goes free of estate tax. But the first $9.1 million goes to your heirs free of estate tax. As of January 1st, that number will match the federal exemption, which is in excess of $12 million. But for those of us who've been practicing for a while, in the 1990s, the exemption amount was only $600,000. And think about that for a second, folks. Every dollar in excess of $600,000 was taxed. So throw in a house, a life insurance policy, a retirement account, and suddenly you had a 55% tax imposed on the excess over the $600,000. It's a little bit of a generalization of the way the brackets work, but it was extraordinary. Fortunately, very few people fall into the estate tax trap anymore. However, there's nothing to say that this can't change. While the exemption amount today is $12 million, if nothing happens by 2026, it's going to drop down to somewhere around 5. Last year there was talk in Congress of dropping it to 3. We don't know, in other words, what's going to happen with the estate tax. So we need to be aware of that when we're drafting our plans. That's why we ask for financial information when we talk to you, so that we know what we're dealing with and how we can best advise you if indeed things do change. So let's talk about multiple residences. Some of them with Connecticut domiciliary, so they own their home here in Connecticut, and they have a house up on the Cape. And they own it jointly, and as most people do. I'm talking about the Cape House right now. At the death of the second, it's going to be subject to Massachusetts estate tax. Now, the exemption amount, I believe, is still $1 million in Massachusetts. So it's not quite as high as Connecticut's, and depending upon where you are, for example, many of the properties on the Cape over the past 5 years have exceeded people's wildest dreams in terms of value. Even we saw a larger increase on the Cape than we did, say, here in Connecticut. But it's something to consider. So how do we fix that? How do we get it out of the Massachusetts estate tax trap? Oftentimes, what I will recommend is doing an LLC. Drop the house into the LLC. What does that do? It actually changes the tenor. It changes what the property really is from a tax standpoint. It takes it from being real property and turns it into a business entity, if you will, for lack of a better term. Massachusetts has jurisdiction over real estate. It can tax real estate. It can't tax a Connecticut LLC. So we've avoided the estate tax. I take it a step further, and I generally have the folks transfer that LLC to their revocable trust. No compelling need to do so, other than the fact that you know where it is, you know how it's owned, and the trust becomes the will substitute, if you will. So it kind of helps move the property where you want it to go ultimately. Because oftentimes with out-of-state property, it's often a vacation home, and it's often something that the family wants to hold on to for a period of time. You know, we've seen multi-generational trusts set up for vacation properties. Those are all well and good. They can be very dangerous, however. When you do a trust that's meant to go multi-generational, so it's possible your great-great-grandchildren could have an interest in this house, think about it just logistically. So you have 3 kids, each of those kids have 3 kids, and each of those kids have 3, so you've got, what, 27 great-grandchildren? All who have an interest in this property. Are they going to get along? Are they going to agree? Will some of them want out of this? So if they own a 27th of this property, how do you deal with those things? If they want out and the others don't want to buy them out, you're creating issues for generations below you. So I generally have people think long and hard about it, because it may not be something that is workable. Some of the most horrific disputes I've had in the probate court have been over things like that. And the only people who come out of it happy, and they're not really happy, but my billable hours go up exponentially. And while it's nice for the bottom line, it's not nice to watch a family disintegrate. And I'd much rather avoid it if we can. So this goes back to talking about using an LLC. And in 2019, Connecticut kind of got wise to what people were doing by using an LLC. So for non-residents of Connecticut, so you've established your domicile in Florida, and you own real estate here in Connecticut, the easy answer before 2019 was that LLC maneuver. You drop it into the LLC, Connecticut no longer has jurisdiction to levy an estate tax against it. So in 2019 they said, nope, no you don't, not anymore. Now, if you put your Connecticut property into an LLC and you're not a Connecticut resident, and that LLC doesn't match up or doesn't pass the test that the state imposes on that LLC, they're going to bring it back in for tax purposes. Now it's disregarded as an entity, if you will. So what's the test? If the LLC does not carry on a business for the purpose of profit and gain, the ownership of the property by the entity was not for a valid business purpose, or that the property was acquired by other than a bona fide sale for full and adequate consideration, and the decedent retained the control over the property, the state is going to maintain that it has jurisdiction to tax that for estate tax purposes. Now again, we still have a $9.1 million exclusion, but again, those numbers can change. That $9.1 million, again, is tied to the federal. If the federal drops, the state drops. So, how do we get around that? There aren't too many ways other than renting the property. And I think it would have to be, although nobody's tested this yet, it's still fairly new. I think the test would be, are you really renting the property? Are you really taking an income that is reportable on your 1040? That would be as close as you can get. I mean, you also need 2 or more members of this LLC in order to be effective. So we've talked about most of this. So when we talk about estate planning and we talk about having residences in multiple jurisdictions, we want to know, well, what's the nature of the property? Are we talking about a single-family residence? Are we talking about a cooperative? Are we talking about a condominium or a timeshare? We want to know how the property is titled. Is it joint tenants with rights of survivorship, generally between a husband and wife? That's how it works. It's, you know, as we call joint tenancy, so at the death of the first spouse, it passes by operation of law to the survivor. And we want to know where it's located and whether or not it's a rental property. If it is a rental property, regardless of the estate tax considerations, regardless of where it's located, I suggest to folks that they ought to be thinking about doing an LLC. If for no other reason but for asset protection. If the home is owned through an LLC, it gives you a layer of protection because it's the entity that owns the property, not you individually. So from a logistical standpoint, if you're thinking about it, if you haven't already purchased a property in another jurisdiction, or you have and it's something fairly new, or you've had it for a while, if your attorney doesn't know about it, talk to them about it. Because there are things that can be done now that will help you, it will help your family down the road in terms of planning, in terms of how that property is ultimately disposed of. The next thing I do from a logistical standpoint is if I have folks who are moving to another jurisdiction, the first thing I do is find local counsel, if I don't already know someone there, and make the introduction. Because I want them to have competent local counsel who, for example, in Florida, I am not admitted to practice in Florida. I have many clients there, but they all have local counsel who can advise them and who can give them, you know, the proper advice relative to that jurisdiction. If you don't have a revocable trust and you have property in Florida, you need a revocable trust. If you're a resident or a domiciliary of Florida, I advise all of my clients to create a revocable trust and to put everything they own into that trust. In Connecticut, we're a bit ambivalent as to whether or not we fund a trust, because the estate tax is what drives all of the work when someone dies in Connecticut. In Florida, it's much different. And, oh, by the way, in Connecticut, they impose a statutory probate fee, and it's based upon the estate tax return. So you could put everything you own in a trust, avoid probate 100%, and you're still, your family, more to the point, is still going to be charged that same exact probate fee. So it's less important in Connecticut in most situations, but in Florida it's critical because you avoid probate altogether in Florida, and Florida has no estate tax. So the property immediately passes on to the next generation, to your designated beneficiaries at that point. You should also think about a new power of attorney. I prefer, if people are changing their domicile, just to do a new power of attorney for sure, but have all of your documents checked. The documents we draft here are generally good no matter what jurisdiction you move to. So there should be no compelling need to rush out and do a new trust or those sorts of things. But think about that and consult with a local attorney there. So no matter where it takes you, a little advanced planning will give you peace of mind, and it will help the next generation enjoy more of what you've left for them. Well, thank you all very much. I appreciate it.
My presentation is much more high level and less detailed than a lot of the other ones, and hopefully will also be shorter. But I'm just going to kind of give you an overview of a lot of the different situations and changes that you might want to keep in mind when you're thinking about keeping your estate plan up to date as your life changes and your family changes and the laws change. So first of all, changes to your personal situation, changes to your marital status. So when you get married, one of the things that you're going to want to make sure happens is that your new spouse is included in your estate plan, if they weren't already to some degree or another. Similarly, if you get divorced, every state kind of has different rules as far as what automatically happens when you get divorced. Some states will automatically revoke provisions related to to your ex-spouse in your will and your beneficiary designations and your powers of attorney, just any of those documents. But in Connecticut, at least the last time I checked, it only revokes them in certain documents and not in other documents. So you just really want to make sure to visit an attorney and make sure that either your ex-spouse has been removed, or there might be reasons that you want to keep your spouse there. Like say if they're the ones who have primary custody of your children and you actually want her to be the beneficiary of life insurance or whatever the divorce decree says. So you just want to make sure to double check and make sure that that is still the way that you want it to be. Domicile and citizenship, I won't go into domicile too much because Jim already talked about a lot of the details for why you would need to visit or revisit your estate plan when you're changing domicile. Similarly, citizenship, there's some different tax rules related to citizenship, especially with regard to estate and gift taxes. So if you're a non-citizen in the United States, there's a lot of provisions that we're going to want to include in your estate planning documents to make sure, basically to utilize as much of the tax credits and make it as tax efficient plan as possible. But also if, like I recently had some clients who hopefully in the next any day now will become US citizens, and then there's a lot of language and a lot of provisions that we can take out of their documents and really simplify things. So it's one of those things that is a major life change that you're going to want to make sure you revisit your documents. The type and amount of assets. So out-of-state property is another thing that Jim already went through. There are multiple planning opportunities there, both to simplify the probate situation when you pass away, but also to make sure you take care of whatever different state tax issues there are. Bitcoin and digital assets is one of the new ones that, we didn't have to deal with nearly as much 10 or 20 years ago. Cheryl, if you're interested in cryptocurrency in particular, Cheryl, one of our associates, has a series of blog posts on our website kind of going through the specific considerations you're going to want to look at when you're just because some of the cryptocurrency can just kind of disappear if you don't have the right stuff or you didn't communicate with the right people. So there's some specific unique things that you need to consider when you have those types of assets. Specific gifts of any kind. So say there's a family heirloom that you want to make sure goes to a specific child or to your favorite niece who really enjoyed whatever the item was. If you don't have that in a will or in a revocable trust or some other kind of will substitute, that probably won't get to the person you want it to unless you specify it in your documents. Same thing with something like real property or a vacation home. Maybe there's only one child who really ever used your Cape Cod home and they're the one that you really want to make sure has the property. But again, that won't happen unless you specify it in your documents. Lastly, just estate tax issues. So like Jim said, when we have new clients or when we have clients come back to us for a review, one of the things that we ask for is a lot of information about what types and amounts of assets you have so that we can look at the estate tax picture, what the laws currently are, and what your situation looks like to see if there's anything we need to worry about, whether now or in 5 years or whenever we think the laws might change. Capacity issues is something that Alyson also touched on, but there are a couple main ways of dealing with incapacity. One of the simplest ones is just a power of attorney and a healthcare instructions designation of healthcare representative. But we've had a lot of clients who, when they've gotten a little bit older and they're sort of more worried about more imminent possible capacity issues, will change to a revocable trust plan. And to the extent that you fund that trust, it can sometimes be a smoother and more efficient way of dealing with incapacity. So we've definitely had clients decide to stick with the simple will-only plan until they get to a certain point where they're, they've been thinking about this revocable trust in the back of their mind, and maybe they think at this point, now's the time to pull the trigger on that type of plan. So depending on where you are and how you're feeling about that, there's some different things that you can plan for. Changes involving your family and I'll call them trusted persons. So children and other beneficiaries. Minor children are one of the big things that people think of. I personally, even though I'd been doing planning for 2 or 3 years, didn't put my own plan into place until I was pregnant with my first child, my daughter. And I realized that no matter what, I was going to be in a hospital at some point, and I was going to want to make sure that my husband had whatever authority he needed to make whatever decisions he needed. So it was actually in the spring or summer of the pandemic of 2020, and Jim and his paralegal and my husband and I stood in the parking lot at our Southbury office and signed across the hood of our car so that we could be socially distant while we were taking care of all these documents. But that's just sort of one of those random stories. I'll always be able to tell exactly what year or what was happening when I actually put my estate plan into place. But minor children in general, you're going to want to make sure that you have a will that sets who the guardians are going to be if you and your husband or the other parent of the child, who's going to take care of them if you're not around. You're also probably not going to want them to get some kind of inheritance outright. If there's millions of dollars in your estate, you're not going to want a 12-year-old or even an 18-year-old or 20-year-old really to get it. So you're going to want to figure out who's going to be in charge of that money instead, who's going to be handling that until you think your child is going to be old enough to take care of it themselves. Similarly with growing children, and we a lot of times will have clients come back who had some kind of structure in place with trusts until a certain age when their children were very young, and then they'll come back maybe when their children are teenagers or a little bit older, and they have a better idea of how responsible their kids are going to be, how good they are with money, if they're going to have any other kinds of concerns, which I'll talk about in a couple items. So some people will either maybe get rid of trust altogether if they're really not worried about their 20-something children getting an inheritance outright. Some clients will decide that they picked ages that were way too young the first time, and they will bump them up 10 or 15 years the next time. So whichever way that goes, as your children grow and you get to know them better and know what the situation is going to look like, you can make changes to your plans then. Blended families is a big one that's really important to do planning for, because especially if you and your spouse bring children of each of you into the marriage, there's some planning that you're going to want to do to make sure that your whole family's taken care, that both of your families are taken care of. So, maybe the simplest plan is when I die, I give everything to my spouse, and then when my spouse dies, their documents control where everything goes after that. But if you have a blended family, let's say I pass away and my husband and I both have our kids from our own marriages, everything goes to my husband. I have to trust him a lot, and I have to trust the people that he's going to meet a lot to make sure that my kids still get something when he passes away, right? So there might be some trusts or some other planning that I want to put into place just to make sure that everybody gets what we decided on now instead of relying on whatever my husband's going to do in the future. The other thing that you can think about with children or just any other beneficiaries is, do they have any special needs that you're going to need to plan for? That could be something like a special needs trust, like if they have some kind of disability or some kind of condition where they're going to get government benefits, there's a certain type of trust that can protect assets, make sure that they have a trust to provide above and beyond what those what those benefits will provide, but preserve their eligibility for those benefits. Or it could just be something like, they have a spouse that you don't trust. You want to make sure that their share is held in trust so that their spouse doesn't spend it all, or maybe they have substance abuse issues, or it could be a whole host of things that we ask questions about when we're talking about whether you want to give everything outright to your kids or your other beneficiaries, or whether there's a need for some kind of trust, whether that's for their lifetimes or just until a certain age where you think they'll have worked some of this stuff out. For fiduciaries, this is one that I think a lot of people kind of forget about. So fiduciaries, just generally speaking, are those trusted people that you're naming in your documents, whether it's the executor of your will, the guardian of your children, the trustee of your trust, your agent and your power of attorney. If the lives of your fiduciaries change, so the most obvious one is if they pass away, they're not going to be available anymore. But it could also be maybe they used to be local and they lived next door, but now they live across the country and they're not really the best one to do it anymore. Or it could be that they have their own issues like substance abuse, or they're going through a nasty divorce or something, and it's just really too much for them to handle. You might want to change who you name in your documents. Similarly, the relationships with your fiduciaries could change. So grouping this with the sort of growing children again, like when my parents redid their documents, I became an estate planning attorney about 5 years ago. And one of the things I did was to make sure my parents redid their documents. And they had still named, siblings who they were close with at the time when they did them, but they're not really so close anymore. And then now they had a, 30-something daughter who does estate planning who would probably be a better fiduciary than whoever they named before. So that's something to reconsider too, because a lot of times people will come in to redo their documents and they might not even, you tell them, okay, well, your current will says that you named this so-and-so as your person, and they're like, oh my God, wait, what? I didn't remember that. And that's not at all who they want to have. And so with growing children too, it's as your kids get to they're in their 20s or their 30s or something, like your kids might be your main people at that point, right? Like you're not going to name them as your executor or your trustee when they're minors, but at a certain point, they're probably the ones you trust more than anybody else, to a certain degree. So that's another thing to think about as your family gets older too. Last of the categories is changes in the law. So estate taxes, Jim did go over this, but just to reiterate. So where we're at now in Connecticut, the estate tax exemption is $9.1 million per person this year. The estate tax exemption federally is slightly over $12 million. And then next year, the Connecticut exemption, at least under the current law, is scheduled to match the federal. So it'll be a little higher than whatever it is now, but somewhere over $12 million. As Jim mentioned, in 2026, the federal exemption is scheduled to snap back to, it's adjusted for inflation, so who knows the exact number, but say between $6 and $7 million federally, which presumably, unless something changes in the Connecticut law, that's going to match that too. So the exemption is going to be cut maybe in half or close to it. And as Jim mentioned, there have also been recent proposals, recent in the last couple of years, to maybe go down to $3.5 million, or I'm sure there are people out there who just want to get rid of the exemptions altogether. So you never really know what's going to happen. So it's something that maybe you don't have to do really extreme planning for today, but it's something that you need to pay attention to and really keep in mind, pay attention to what's going to happen. We try to send emails and things about that when that does happen, but just to pay attention and make sure that if some major changes are happening. And one of the specific things that I'll mention with regard to that, so by old formula wills, I mean, like Jim said, let's say, when the exemptions were $600,000, or say they are $1 million or something, and some people had wills that basically had a formula that said, I want to give whatever the maximum exemption I can give, whether that's state or federal, to a trust to make sure that I use the maximum of my exemption, right? Instead of giving everything to my spouse. When I die, if I give everything to my spouse, I don't owe any estate taxes, but then I haven't used any of my exemption, and my spouse is stuck with the combined, but only has his exemption left, right? So a pretty common plan, or even now when clients have fairly large estates, is to just say, okay, I'm going to give my entire exemption to a family trust to make sure I use up all of my exemption. That trust, the assets in that trust won't be included in my spouse's estate, and so then my spouse still has their whole exemption to use on whatever's in their estate. As exemptions have gone higher and higher, this has had some unintended consequences. So let's say your estate is $5 million combined. The estate tax exemption was $1 million when you put this plan into place. So you were thinking $1 million goes into this family trust. My spouse can benefit from that, but doesn't have total control over it. But my spouse still has like $4 million left. Like that's plenty, that's most of my estate. But if the exemption is $12 million and you still have that kind of formula, will, or trust plan that says I give the maximum exemption, up to the $12 million to this trust, you might end up giving all of your assets to this family trust, and then your spouse is sort of disinherited in a way, which they might not love. So it's one of those things that if you have one of those kind of plans, especially if it was done when the exemptions were much lower, you're going to want to revisit it and just make sure that might still be the plan you want, but just make sure that it works the way that you think it will. All right, well anyway, so if you want a lot more information, there's definitely more information in our YouTube channel. But one of the biggest changes was how long a beneficiary can stretch out distribution. So it used to be that pretty much all individual beneficiaries, so whether it was a spouse or your child or whoever it was that was a beneficiary of your retirement accounts, so your IRA, your 401k, that sort of thing, could basically stretch, bless you, could basically stretch out the payments of this IRA or whatever retirement account for their lifetime. So if you had a 20-year-old child, they're going to have a pretty long life expectancy that they can stretch these payments out and also sort of keep income taxes down, like spread out the income taxes for that long. The Secure Act changed that for most individuals. So the surviving spouse can still keep the stretch out for the most part. And there are certain other eligible designated beneficiaries, like if you have a disabled child, they can usually have the stretch out. If you have a minor child, they can, until they're 18, their 10 years doesn't start yet. But for the most part, there's a 10-year rule basically for distributions out of this retirement account, unless you're a spouse or you fit into one of these special categories. So less than sort of estate tax planning, it really has income tax planning consequences. So that's one of those things you're going to want to figure out is whether or not your plan, how you're going to figure out how to do that. And if you want to pay it to a trust, like if you have a minor child or some other reason that you want to pay it to a trust, you really need to make sure that the trust is set up the right way to still preserve the 10-year payout or the stretch out for your spouse or whatever it is that you're trying to do. The proposed regulations have come out, and I think Richard said that he updated the video with some detail, but not as much as he would like. But the biggest sort of surprise for most people was that the 10-year rule, when we got the actual Secure Act, most people thought that you didn't have required minimum distributions. If you fell under that 10-year rule, that you could just wait until the 10th year or 11th year, depending on when the person passed away, and just take everything out then. So you could kind of keep the growth tax-free and they're in for 10 years. The proposed regulations say that actually you do have to take required minimum distributions over those 10 years, but they're not final regulations yet, so it's still kind of unclear what's going to happen with that. So it's one of those things to kind of keep an eye on and just another tax thing to kind of consider when you're doing your plan. In general, I think my slide for this used to say revisit it once every 5 years, but now I say every 3 to 5 years or so, just as a general rule. Doesn't mean you necessarily need an update, but just to double check and make sure that everything still looks good. Revisit sooner if any of the things on the previous slides happened, whether if your life changes, your family's lives, or the lives of your fiduciaries, or law changes, like if the estate tax exemptions change drastically, it's a good time to come back to your attorney. That's the rest of my presentation.
And I suppose you're all wondering how I got this job as MC, which I guess I am not doing such a very good job at. In 1994, I was a contestant on Jeopardy, and I lost. In about 2014, I was a contestant on Who Wants to Be a Millionaire, and I lost. So they wanted to give me this one chance to redeem myself, and Liz has pointed out that I apparently lost. But in any event, our last speaker of the evening, Shelby Wilson, practices primarily in our Westport office. For those of you who don't know, we do have an office in Westport, as well as Southbury and our main office in Danbury. She will be speaking about estate planning and business succession issues, and that's really one of the really most important things for people who own a business, is how they're going to pass that on, how they're going to deal with it. There are lots of complicating factors. And Shelby?
My goal in this is to kind of give you some nuggets of information and things to kind of think through. I usually would start this by asking the question of how many business owners are in the room right now? Okay, we got quite a few. All right. Okay. So some of this you may know, and other things hopefully you'll pick up on, and I can give you some ideas on things that I see in my practice in working with a lot of closely held business owners. It's just from an introductory standpoint, clients come in all the time and will say, okay, I want to start a business. And that's, sort of part of what we do, both on the estate planning side as well as in the corporate department. And the first, real question sometimes becomes, okay, well, what type of business are you in, and what type of entity are we really looking to create? And this is kind of the cradle of the business practice. And there are several different types of businesses. And again, I'm not going to list through all of them, but just sort of give you a general idea. Simple as sole proprietorships, where you're really not incorporating. You may have a business and you may be segregating, that business into different accounts and things like that, but it's really not organized, at the state level, or, it may be something that you're doing kind of on the side. And so there are sole proprietorships out there, which really, report their income at the individual level. There are partnerships and limited liability companies. And these are very, very common for a whole, multidisciplinary businesses and different, different industries. So very, very common. And a lot of times when we have clients that will, from simple as having a rental home to, to a much larger business, clients will have partnerships in LLCs. Some of these will have multiple and many shareholders. Others will be single member LLCs. So it sort of covers a whole myriad of situations. There are professional corporations. S corporations, which are a little bit less common in Connecticut because LLCs and partnerships are so easy to form, as in many states. Those have sort of taken the place over the years in many respects of S corporations, although there certainly are still, still reasons to have S corporations as pass-through entities. And there are also C corporations. Typically, those corporations are larger, have many shareholders. It's an older form of corporation, but they certainly still exist today. And there are different reasons to have all these, or to choose one or more of these types of entities in order to, to set up a business, or in the process, I should say, of setting up the business. Is it appropriate to have a board of directors? What are the administrative costs? What are some of the tax ramifications of some of these different entities? So really, in starting a business, you want to go through with probably both your tax advisor, your accountant, as well as your attorney, and really parse through, what is the most appropriate entity. I've had, clients that have started C corporations, for instance, for multiple reasons, and they can be completely legitimate reasons, but not also understanding that when those businesses wrap up, for instance, and dissolve, there's some pretty significant processes that need to go through, as well as some significant tax consequences that you need to be aware of. And so it's something to certainly keep in mind. So the questions that we typically will ask, from the outset, are what type of business are we looking at here? Is it something that, is going to require regulatory oversight? Is it going to, how many people are going to be employed by this business, or how many people are employed by the business? that's certainly going to, affect what entity and kind of how things are going to move forward. Do you have partners and other shareholders that are involved in this? That's certainly going to impact that as well. What are some potential creditor or malpractice issues that could come up? I have a client now who's been a client for a number of years, for instance, and has decided, that she wants to start her own business, and it's a it's a kind of medically related practice where she wants to make house calls. And she has, a number of assets on her own. And, my biggest concern for her in her position is, okay, what about malpractice? How can we, how can we best put you in a position where this business that you are excited to start is not going to result in some type of claim at some point down the line that could have a significant impact on the other assets that you hold either in your name as well as in trusts and so on and so forth. So so that's something that comes up. How can this business potentially be attacked at some point in the future by outside creditors? What tax issues come down the line? And how does that impact how we're choosing, what entity we're choosing? For instance, and this is just a couple of examples here, we have S Corps, where only wages are subject to things like FICA, Social Security, Medicare, whereas we may have other pass-through entities where we have a qualified business income deductions, and it's just we need to really sit and consider how the income is being made, what wages are being paid out, who is being paid, how many shareholders do we have. So the analysis can be, quite important from the outset on this, and really should be done. I always suggest that it be done, as I had mentioned earlier, in collaboration with an accountant and potentially other business advisors that may be involved. The other thing to also think about is, I actually represent a lot of franchisors, and what other, entities or kind of parent entities are going to be involved, if any. And so that can really, in many cases, dictate how you go forward, because there may be kind of a higher power in the chain of businesses that you're dealing with that are really regulating a lot of what's going on. So just things to be aware of. Okay. Are there additional business owners or interest holders? Okay. What kind of incorporation documents and organizational documents are out there? What kinds of rules are we dealing with, in essence? What has already been in place for businesses that are existing? And what do we need to follow? So it's very common in going through transactions, especially in estate planning, where we find out, that we go back to organizational documents, and clients will inevitably, in many cases, not have revisited them in a number of years, and find out that what we're doing is really, in contradiction with bylaws or conflicts with bylaws. Or other, LLC operating agreements or other provisions that are in the organizational documents. And so many times that has to be, dealt with, and those issues have to be resolved before we go through and actually effectuate whatever the client is looking to do. So we have to look at buy, sell, and shareholders agreements as well if they're out there. And if they're not, I always recommend to clients, that's something to consider. Many times when business owners start a business, they're not thinking 20 years down the line, because let's face it, when you're a business owner, and you're starting a business, the priority is probably not what's going to happen at some point in the future. The priority is to start building that business and kind of deal with the rest later, until you hit a point at which you may have other shareholders and you may have intervening factors like a death or a disability or retirement, or somebody wants out of the business, and then you realize there's really no set of rules. Or when business owners want to transfer interests and we're unsure of whether that can be done and who permitted transferees may be. It's something that becomes very relevant, sometimes at an inopportune moment. So a lot of times, especially in situations where there are closely held business and family members involved, and even if there aren't, we will encourage clients to consider things like buy, sell, and shareholders agreements. What happens when somebody wants out of the business? And it's all well and good when you're organizing a business and everybody is in love. It's not so nice when you have situations which inevitably happen every day of the week, with shareholders and partners that no longer want to be involved. Things like operating agreements. A lot of times when businesses, especially, I see this most often with LLCs. The question is, well, we don't really need an operating agreement. I don't want to go to the expense of putting one together. And that's all well and good until we have multiple shareholders that do have these issues, and there's really no document that's governing what happens in the future. So as much as it seems like it's very burdensome to go through these processes, and a lot of times I hear from businesses, business owners, let's just let it ride. We don't really need to do this. Usually when things kind of become problematic, it's too late in the game to get everybody on the same page. And that's really what happens in terms of, when you see these disputes going on. A lot of times also in family businesses, I find that there's always sort of especially when there are multiple family members involved, the business owners oftentimes will have ideas as to, which parts of the business or where things are going to sort of shake themselves out in terms of, family members either inheriting business interests or eventually buying business interests or otherwise receiving them. And it's always good to memorialize that. And I find that I would say that the clients that have really brought businesses to multi-generations do it through communication and through memorializing exactly what the plans are ahead of time. And that's where it just takes the question out of everybody's mind as to what the intent is, and keeps the businesses presumably or hopefully into the future productive. Who are the officers and management of the company, especially in cases where there are clients that are contemplating retirement at some point in the future? Who's going to run the business going forward? Oftentimes it's something that clients don't really or have not really had the chance to think through. And so, that's something that we discuss very extensively with clients over time, is to, where do you see this business going at some point in the future? How do you feel? And I've often asked the question, and it sounds terrible, but how would you feel if your ex-son-in-law or soon-to-be ex-son-in-law becomes your business partner? Or how would you feel if your daughter-in-law steps into that role? And oftentimes I get a response that, wow, I can't imagine that happening. Well, in some respects that's reality. And the best way to address that issue is to to have some rules in place and some proper documentation in place to be able to to combat that when the time comes that a triggering event, so to speak, occurs. So I'm going to segue into more of administration. What happens when we have to administer an estate or a trust, or what happens when somebody passes away with a business interest, and what kinds of things, what kinds of issues do we face? I've settled a number of estates, a large number of estates, where we're left with a business interest that we either knew about or we didn't know about. Issues inevitably come up, many of which we don't anticipate. First of all, logistical issues. What happens? How does a business continue to operate when an owner passes away or an officer passes away? And many times, the most important thing that we have to deal with right out of the gate is the retention of necessary employees. And I always say, in dealing with clients with closely held businesses in particular, one of the things I always try to do is try to get to know who the key players are in any given business, whether it's a CFO or a CEO or somebody else in the business, whether it's many times it can be an executive assistant, or it can be somebody that has the knowledge of the business and kind of understands the inner workings of it. And so that's something, retention of necessary employees and familiarity with the business is something that, becomes very important. And these are just things, I'm sort of putting up random things up here, and they seemingly are very random, but these are things that we, as lawyers, when we're going in and doing, looking at a settlement and looking at a business, these are kind of the common things that are common items that we see, and there are others that are out there as well. I'm kind of pointing out some of the ones that we see most commonly. Loans to and from shareholders. I can't tell you the number of businesses that will have these simply because it's loans for working capital. A lot of times, shareholders are loaning money to businesses, and nothing is really. Sometimes, it's in book form, but there are no notes that are out there. And so that, can become difficult if there's not appropriate paperwork, and can create, some pretty significant issues in ongoing administration. There are outstanding liabilities of the business. What's out there? What bills have to be paid? What creditors are out there? I had an estate years ago where we had a business that eventually wound up being sued by about 6 different entities, and the business, quite frankly, became simply a checkbook to pay legal fees to defend itself. So that's another thing that we typically will look at. Tax liabilities. I did a program years ago on what happens when you find out eventually that that the gentleman or woman that passed away had outstanding liabilities and the business has outstanding liabilities. These are things that we have to go in and deal with, as part of administration, and it's something that's important to understand, ideally, while the person is still with us. And again, daily management of the business, that kind of goes along part and parcel. How is this business going to move on? Is the business going to move on at some point in the future? Or are we looking at a business where we really have to, the goal is to really wrap things up? So these are just some things to think about. What do we do on this? What are some general pieces of advice I have to give to, to closely held business owners? Review and understand your organizational documents and shareholders' agreements. We had a client not too long ago that had multiple LLC operating agreements, all with contradictory terms, same owners, series of business, and we had no idea how interests in this business were ever going to be transferred, and each operating agreement had a different set of rules. And so that's something where, and it was simply a matter of, a form operating agreement being used and not understood. And so, a business would crop up, and there was an LLC that cropped up, in 2014, another in 2016, and operating agreements, probably form operating agreements, were used from a multitude of sources, and none of them were consistent. Became very problematic. Understand the business. That's, probably what I spend a lot of time doing in working, or regardless of, what industry the client is in, I spend a lot of time trying to understand that business, understand who's involved. And what I find most helpful, and it's interesting because clients sometimes are more or less reluctant to do this. I'll ask for a tour of the business. I'll ask to meet employees to the extent that that's feasible, and to understand who's in charge of that business, regardless of how large or small that business is. Coordinating business plan and estate planning documents. I worked for a firm years ago, and I had a partner in the corporate department of the firm, and I remember meeting with a client and saying, and this particular partner saying, okay, I'm going to do your business succession planning, and then you're going to go over to Shelby and do your estate planning. And it was very sort of siloed in a sense that those roles were split up. And, and there was really no coordination between business succession planning and estate planning. And I see the process as being it's essential to have those two attorneys or that team being on the same page. And so, for instance, my practice cannot exist without a very strong corporate and real estate practice that I collaborate with, because I see it as all part of the same process. And I'm settling an estate now where, I was not involved in any of the business succession, and the estate plan is really not in contradiction to the business succession plan, but there have been all sorts of issues that have cropped up, with regard to the sale of the business versus a beneficiary of the estate actually receiving shares in the business. So very important to have your estate plan and your business plan coordinate, and to have the terms of those plans be consistent. Otherwise, especially in families where you have children that are in the business or family members in the business and the others that are not, it's going to lead to a lot of disgruntled feelings and, potentially, in the worst case, some litigation. Let's see. be aware of what happens when a business owner retires, becomes disabled, or passes away. A lot of times, as part of estate planning, we will take a look at that. And it's very, very important to be able to provide the attorney with the information and any organizational documents to be able to make sure that your goal as a business owner is being met on that, and that your expectations are not thrown off by by conflicting provisions. Prepare business owners to conduct appraisals at various points in planning. So this really becomes a real sticking point for many business owners, because appraisals can be expensive. And so when we do planning, and sometimes when we do gifting, or we're contemplating that, we need to have updated appraisals to be able to kind of move forward and be able to do the proper reporting and advise properly. And so, that's something that I try to, and it can become a sticking point, as I mentioned, but try to have business owners really understand the importance of getting a good value on different interests at various times. And that can be hard, because you're really towing the line between asking the client to spend sometimes what's not an insignificant amount of money for something that may seem in many respects obvious to the business owner. Sometimes it's surprising. I always think, be practical. There's so many arrangements to consider. There's leveraged gifting arrangements for businesses that, that we do for tax purposes. And they're all different arrangements that, and options that business owners have, to be able to minimize estate tax and to be able to do some really good business planning over a period of time. But many times we have to kind of step back and think, okay, this may not make practical sense for the business owner. Consider relationships between and among business owners. So, what we sometimes forget, and we need to always keep in mind as lawyers is, we want to create a harmonious business. We don't want to do a client more harm than good by, if we represent a specific shareholder, for instance, or we represent a group of owners. We want to make sure that the business at the end of the day is, remains harmonious. We don't want to create accidentally a situation where, we have business owners that are at odds with one another. And so we always have to keep in mind that, you still have to go home and run a business. And this is probably the most important thing at the end is business succession takes a lot of time. If it's something that a client thinks they're going to do in a month, probably unrealistic. I've had business successions plans that have taken 12+ years. And it's something that can't be done in a vacuum. It really needs to be coordinated with an estate plan. And it does take time and consideration for a multitude of different reasons. So something that can get quite involved, and communication is key. But it's something to give a lot of thought to, and take your time with, and give yourselves enough time to really make some good decisions in the interest of your family as well as the business. So hopefully that's helpful.